Members of the Judiciary Committee, I am Senator Megan Hunt, M-E-G-A-N-H-U-N-T. I represent District 8, and I'm here today to present LB1148, a bill that would provide a clear standard for parent-child relationships for kids that are conceived through assisted reproductive technology. So think of IVF, sperm donation, anything other than the first thing we're taught about in school, you know. The impetus for this bill was an email that I received over the interim from a man whose father was a sperm donor. He lives in Utah, so he isn't able to be here, but as an adult, he's connected online with his half-siblings, and one of them is from Nebraska, so that's his connection to Nebraska. And that kind of spurred his advocacy for us looking at our parentage statutes. His name is Jack, and he submitted an online comment in support of this bill that you can look at too. Some quick history about where assisted reproductive technology has come from. The first successful documented artificial insemination that resulted in a pregnancy was in 1953. Prior to that, American cultural attitudes toward donor insemination were more archaic, that the use of donor sperm constituted adultery and resulted in an illegitimate child. But as science advanced to make this breakthrough more accessible to would-be parents, attitudes toward donor insemination started to turn, and by the 1960s, states began adopting statutory language to recognize these children and grant legal parental status to non-biological fathers. Georgia was the first state to develop its own law, and many others followed when in 1973, the Uniform Law Commission and the American Bar Association approved the first Uniform Parentage Act that year. If you're not familiar, the Uniform Law Commission is a bipartisan group of legal experts from across the country that creates model legislation as standards for states to adopt and avoid patchwork laws. At that time, there was a widespread assumption that these kids conceived through artificial reproductive technology would never know who the biological father was. And we know now today with the advent of DNA testing, and now you can even do DNA testing in your home with 23andMe and stuff like that, it really changed that. And now adult children of donors can easily and affordably do a genetic test at home. They can identify their biological fathers and biological siblings that they may not have even known about. And donor insemination, sperm donors, are no longer the primary form of assisted reproductive technology either. Women can donate their eggs, couples can donate embryos, in vitro fertilization can occur with or without the use of donor sperm, and these methods have become common for couples who are struggling to conceive. With all of that said, knowing the lay of the land with this technology, Nebraska law has not kept pace with modern forms of technology and the rise of more and more kids being born through these type of technologies. And this is practically leaving these children and parents on some precarious legal ground, and the courts have no clear legal standards to follow. While a majority of other states have adopted some edition of the Uniform Parentage Act or developed their own law to address these situations, including most of our neighbors, Wyoming, Colorado, Minnesota, Missouri, Nebraska has been stuck in the 1950s as one of the few remaining states to statutorily address parentage and assisted reproductive technology in some way. Another thing happening is across the country, informal sperm donation has surged, driven by the internet and shifting ideas about parenthood. There's online platforms like Facebook groups, there's websites like Known Donor Registry, and it's made it easier for Nebraskans to connect with donors outside traditional medical settings. While this provides hope for many families, especially in rural areas with limited access to fertility services, it leaves children born through these arrangements with uncertain legal parentage. Without clear laws, children face risks such as inheritance disputes, lack of parental support, or custody conflicts, most commonly. The gap in Nebraska's laws is increasingly concerning as diverse family structures continue to grow. LB1148 would address some of the legal complexities for parents who use assistive reproductive technology. My staff worked with drafters to adapt the ART, assisted reproductive technology, ART-related portions of the 2017 Uniform Parentage Act to fit within Nebraska statutes. It's one that 11 states have now adopted, and it updates the previous 1973 standards. Nebraska needs a clear framework for establishing legal parentage in cases of assisted reproduction, including informal donations. By following the example of the many other states that have passed some uniform standard, Nebraska could proactively protect children, donors, and intended parents, ensuring legal parentage aligns with today's realities while reinforcing family stability. Without this bill, parentage and the legal rights and responsibilities that come with it, like child support, inheritance, medical decisions, are assigned just based on biology rather than what family structure that kid is actually in, born and raised in. Currently, many couples also have to undergo a second parent adoption process in order to establish a legal parent-child relationship for the non-biological parent, which can cost tens of thousands of dollars. There's a recent court case where the state of Kansas sued a Craigslist sperm donor for child support, won, and then lost it on appeal. Its mirror image happened in Minnesota, where an informal sperm donor's suit for custody was only denied at an appellate level, which played a major role in the state's adoption of this law last year. In New Jersey, an informal sperm donor sued a lesbian couple for custody and won. A case in Pennsylvania made it all the way to their Supreme Court this March, trying to sort out parentage for a lesbian couple who underwent IVF and then separated before the child was born. Another risk is that biological connections identified through genetic databases can be weaponized by quote-unquote surprise heirs or newly discovered half-siblings, or turn into unwanted legal claims like inheritance disputes. I'm sure there are many more cases like this that haven't made the news, and I think we can expect even more in years to come, which is why we need to clarify the law. All of this is costing affected families and taxpayers a lot of money and legal resources, and also creating uncertainty in the lives of the children that are involved. The only obvious winners from the present arrangement that we have in Nebraska are family law attorneys. It's also, by and large, not happening in states with more recent versions of the Uniform Parentage Act, because the courts in those states aren't having to make up the law on the fly. But our current statute's silence on these topics leaves us open to complex interstate paternity disputes that could easily be prevented by codifying clear statutory guidelines regarding parentage. I want to highlight for you that we are fortunate to have 2 members of the Uniform Law Commission here who are ready to share their experience with the committee. Mr. Larry Ruth is here from the Nebraska chapter of the commission, and Ms. Libby Snyder came here from Chicago to be with us today as a subject matter expert. I believe they will easily hit their time limit, but they told me that they are happy to take additional questions from committee members concerning the history and background of the commission, and also the practical applications of the language that we've proposed through this bill. As you know, I am not an attorney. This is not my level of expertise. This to me was just more of a thing that we go through as senators, where someone reaches out to your office with a problem and there's a solution, and so then you're the one to bring it. And I think that my office did our best to try and come up with a solution for this problem. I'm of course open to, whatever feedback experts have and whatever feedback the subject matter experts on this committee have. There is a clear need for Nebraska to update this area because it's currently silent on these situations, and we do see in other states that there are disputes, it affects kids, and it costs taxpayers. This bill would move Nebraska in alignment with nearby states like Wyoming, Missouri, North Dakota, Minnesota, Colorado, and Illinois, all of which have adopted a similar Uniform Parentage Act governing assisted reproduction. So yeah, please advance this bill so we can bring clarity and harmonization for parents and families who are just trying to build their families. So, thank you.
Senator Hunt. Are there any questions? Senator Hallstrom.
Senator Hunt, thank you. In your testimony, you gave examples of a donor who had won a case, lost on appeal, another donor who won the case. And this bill says a donor is not going to be considered a parent, so we conclusively determine that. Am I reading that correctly?
That's right.
Thank you.
That, if you donate the sperm, you can't then claim parentage over the child.
But it seemed like there were cases that
Yes.
went both ways
Yes.
elsewhere.
I've also seen Law & Order SVU episodes about this, so I can imagine cases where that would happen.
And I stayed at a Holiday Inn Express last night.
That helps too. That's supposed to be good for you.
I just have one question. Did you, and maybe you haven't had a chance yet, which is fine also, to read the online comments from Nicole Barrett at HHS?
Yes.
Okay.
So, we're really grateful that they're coming in neutral, happy to address any amendment. you know.
Okay.
Yeah.
That's really my only
No
question.
problem. Whatever, that's all good. Yeah.
Thank you.
Yeah, thank you.
All right, thank you very much.
Thank you.
We'll begin with proponents. Anyone here to testify in support of 1148?
Thank you, and thank you for the questions for the experts, you know. I'm really grateful to all the help that they gave my office in drafting this, and it's really, really a good feeling as a lawmaker when someone identifies a problem for you, and then you can find the people to help you fix it, and it's not something you have to make up, you know what I mean? So this was a really productive process, I thought. What surprised me about working on this bill, and what's really encouraging, is the feedback I've received since introducing it. You know, you talked about how many comments there were, and I know that many people have sent emails to senators, and I thought this was something initially that I was doing for like a very niche group of people, like it wouldn't really affect that many people. But when I heard from the Uniform Law Commission and we talked about how many kids this actually affects, you know, I was kind of surprised by that, and it made me realize how important this really is, that Nebraska doesn't stay silent on the law on this issue. Some of the comments, one woman from Papillion said, you know, that she and her husband were trying to conceive. Her husband's an active duty airman. After lots of heartbreak, embryo donation was brought up as a pathway to parenthood. They were able to find an embryo donor, and they had their daughter, but they have to get their parentage recognized. And so this bill would help them with that. You know, there's many pages. Another proponent from Omaha said that she's a social worker and she knows of a family that had to pursue adoption for the children they conceived via IVF. So through the comments, you can read lots of personal examples of just kind of the legal trouble that through this law we can just avoid for people going forward and make it much more clear, and also align us with standards in other states and nationally. So thank you very much.
Thank you. Any questions for Senator Hunt? All right, that
Thank
will
you all.
conclude our hearing on LB 1148.